Nobody is perfect. The most careful attorneys can make mistakes. But during World War II, the U.S. Office of War Information found a problem with sailors who weren't careful enough with confidential information. So they developed a short slogan that emphasized the dangers of lacking due care with sensitive information. Loose lips sink ships. Welcome again to the lecture series for Ethics in the Legal Environment. I'm your instructor, Roun McNeal, and in this lecture, we will continue discussing one of the more noteworthy aspects of a lawyer's ethical duties, the duty of confidentiality. In the last lecture, we introduced confidentiality. We distinguished confidentiality from the attorney-client privilege, and we discussed a few circumstances when attorneys are either permitted or required to disclose client confidences in order to avoid harm or injustice. But what about unintentional disclosures? Not every violation of confidentiality is intentional. In fact, most are not. Unintentional disclosures are the accidental release of sensitive client information to a third party, and in my experience, they are more common than intentional violations of the duty of confidentiality. This includes failing to properly manage mailing lists, faxes, or emails, all of which can result in inadvertent disclosure of clients' protected documents or other communications. The ethical consequences of these slips can depend on the carelessness of the lawyer and the practical consequences visited upon the client. The obvious implication here is that recklessness with client information can have some serious consequences. If a client is reckless with that information, privilege could be waived and lost, and the communication between the attorney and the client could be used by the opposite party. However, generally, privilege is not lost if the attorney accidentally discloses confidential information because since the attorney does not, quote-unquote, own the information, she is not able to waive its privileged nature. And circumstances may protect the privilege in some cases of unintentional disclosure. Consider the facts of a New York case, People v. Terry. In Terry, the client accidentally mailed confidential and privileged information to the district attorney's office instead of his own lawyer's office. It was a good faith mistake, and the district attorney should have immediately known that it was intended for the defense, not the prosecution. The DA opened the mail anyway. In this case, the court said that the DA was unable to use the information contained therein because the state should have known that the mail was erroneously sent and should never have opened it in the first place. Whether an unintentional disclosure rises to the level of a waiver of the privilege depends upon the circumstances. There are a few fact-specific questions to ask to make that determination. For example, was a reasonable degree of care taken to prevent disclosure? Did extenuating circumstances, such as a large amount of outgoing discovery, create a possibility of accidental disclosure? Was this the only unintentional disclosure, or have there been several such mistakes? What was the extent of the disclosure? Has a long time passed, or did the disclosing party quickly notice the mistake and attempt to rectify it? Finally, an overarching question, is justice served by relieving the disclosing party of the consequences? Well, it's impossible to completely relieve the disclosing party of the consequences because once the other side knows a fact they should not have known, they cannot merely unknow that fact. However, they might not be permitted to use that information at trial. Which brings us to what should an attorney or paralegal do if she or he is in receipt of some information that was unintentionally disclosed. The ethical and practical thing to do is to limit exposure. Stop looking, reading, or listening as soon as it becomes apparent that the information is confidential or privileged. Limiting the exposure may also limit the corrective action that a court might need to take in order to preserve attorney-client privilege and exclude this now tainted information that perhaps might be independently obtainable. The duties of honesty and candor before a tribunal also demand that the sender of this unintentional disclosure be notified as soon as possible. Then, the recipient should follow instructions regarding returning or destruction of the documents or information, or seek a resolution in the court. There's something fundamentally unfair about one side gaining an advantage because of unintentional disclosure of confidential information, and you'll recall that a lawyer's first duty is to justice. Viewed through that lens, the care taken to not take advantage of an unintentional disclosure seems like the most fair and just result. Taking advantage of an opportunity to gain access to privileged and confidential information is the issue in Perna versus Electronic Data Systems, a New Jersey case that deals with misconduct. In that case, Electronic Data Systems, the defendant, was ordered access to inspect some documents in discovery at the plaintiff's office. The defendants were completing their inspection when lunchtime came, so they went to lunch expecting that their belongings would not be touched. Perna, the plaintiff, claimed that he came upon some documents that had fallen out of defense counsel's briefcase, so he picked them up and read them. Not just read them, made photocopies of them. When Mr. Perna's lawyers found out that he had done this, they notified defense counsel, who moved to dismiss Mr. Perna's claim. The court found that Mr. Perna acted in bad faith in photocopying the material and dismissed the claim. Before we close the chapter on this topic, let's address two more issues that are implicated in the duty of confidentiality. First, we need to talk about unprotected communication. And second, we will talk about attorney work product, which is protected but for different reasons. First, unprotected communications are information that must be disclosed to the opposing party if requested during the discovery phase of litigation. Perhaps this is review for you, but discovery is a pretrial process whereby each side in litigation attempts to solicit information from the other side. This can be accomplished through interrogatories, which are lists of questions, depositions, which are live in-person interviews that resemble trial testimony, and requests for production of documents. All of this talk about confidentiality may have the strategy-minded among you thinking, well, if my client has incriminating documents, she should just send them to my office. Then they'll become protected attorney-client privilege. Not quite. Regular business records or other documents that existed before the litigation started are discoverable, which means that in order to get to the bottom of the allegations in the lawsuit, the other side can demand, and you have to comply with that demand, to turn those documents over. Just sending incriminating evidence to the lawyer's office does not cover it with some magic confidentiality. Here's an example to help illustrate. You're a paralegal in a law firm that represents Pharmaco, a pharmaceutical company. Pharmaco possesses an inter-office memo that its scientists sent to the CEO outlining the dangers of a new drug. A class action lawsuit has been filed against Pharmaco, alleging that the new drug causes loss of sense of smell. When the CEO gets wind of the lawsuit, he gathers all the copies of the inter-office memo and sends them to the law office, hoping that privilege attaches. But of course, it does not. That memo is not a communication between Pharmaco and its lawyers. It predated the lawsuit, and absent some other facts and circumstances, it is not privileged. A similar principle is shown in the case of Cangelosi versus Capasso, the facts of which highlight that communication between client and attorney that is not for the purpose of seeking legal advice is not covered by attorney-client privilege. This case involves a nurse, Lisa Bruning, who attended to Mr. Cangelosi after injuries sustained during a skydiving accident. The nurse prepared notes contemporaneous with her treatment of Mr. Cangelosi. The hospital turned those notes over to their lawyers after Mr. Cangelosi filed suit. Mr. Cangelosi demanded copies of those notes in discovery, but the hospital claimed that they were privileged communications because they had turned them over to their attorneys. The hospital contended that Mrs. Bruning's notes were made in anticipation of litigation. But Ms. Bruning had not hired a lawyer, no suit had yet been filed. There was really no reason to believe that when they were made that they were intended to be a communication with a lawyer. The court demanded that the hospital turn over the notes because they were not protected by attorney-client privilege. Finally, on this point, you will distinguish communication from physical evidence. Real physical evidence is not communication at all, so it is not covered by attorney-client privilege. If your client is charged with murder and brings you the murder weapon, you would not be bound or, in fact, ethically permitted to keep the weapon and claim that it is a privileged communication. Now let's finish the unit by talking about work product. Work product is all the stuff that a lawyer has prepared in the course of getting ready for trial. Things like written notes and impressions, graphs or charts, diagrams, and other material used by the attorney to prepare strategy and tactics for trial. All of this is protected, but it is distinct from privileged material. The client does not own work product the same way that the client owns the confidential information she has shared with the attorney. Nevertheless, the law recognizes that factual research, interview transcripts with witnesses, legal memoranda, and other things that the lawyer prepares for trial are all protected because they are a result of the lawyer and her staff's thoughts about the case. An old Supreme Court case recognizes this concept. In Hickman versus Taylor, a lawyer representing a tugboat captain deposed several sailors with some knowledge of the facts of the case. Lawyers on the other side asked for transcripts of that deposition in discovery. Were these deposition transcripts considered protected work product? Spoiler warning, yes. The court in that case said, were materials such as these open to opposing counsel on mere demand, much of what is now put in writing would remain unwritten. An attorney's thoughts, heretofore inviolate, would not be his own. All of this has implications for paralegals. First, nothing communicated between the lawyer staff and the client may be revealed without the permission of the client. True communications between attorneys and clients are confidential. Second, paralegals must know all the details of the litigation in order to perform their jobs well, so they may also be just as diligent about protecting the confidentiality of the client. Since paralegals are more likely to be handling the organization of the office, they need to be diligent about making sure that the client's files are secure when not in use. Confidential material needs to be marked clearly with a stamp or some other obvious marking to reduce the likelihood that it might be accidentally shared. And third parties, such as print vendors, should be required to sign confidentiality agreements. Other types of technology can be similarly fraught. Digital information can go out the door far more quickly than traditional communications. Wireless devices such as Bluetooth are susceptible. When emailing confidential and sensitive material, you should have extra security protections such as password protections or encryptions. And fax machines can be especially risky ways of transmitting confidential data because of misdials and the chance that the confidential information will sit in the open on the fax machine for a while. Confidentiality is a cornerstone of the relationship between the attorney and the client. That's why attorneys have such a powerful duty to maintain those confidences and why the court respects and protects privileged communications between attorneys and clients. Law office staff members must hold themselves to similarly high standards as representatives of the lawyer with the duty of confidentiality. And while some information may have to be disclosed in the interest of justice, and some information is not protected at all, the notions of confidentiality extend even out to the attorney work product that is prepared before the client ever goes to trial. Now, that's all for confidentiality and attorney-client privilege. The next unit in this course deals with a similarly foundational aspect of law practice, an extension of the duty of loyalty with which you are most likely somewhat familiar: conflicts of interest. Until next time.